Now we'll discuss the very provision of Section 9. And that Section 9 provides that who can keep the child in adoption. And regarding that, those who are eligible to give a child in adoption or falling under father or mother or guardian. And secondly, father then consent of the mother unless she has completely and finally renounced the world or ceased to be a Hindu or has been declared of unsound mind. And in case if mother, then if the father is dead or had renounced the world or ceased to be Hindu or has been declared unsound of mind. And regarding both father and mother, if both are dead or renounced the world or declared unsound mind or abandoned the child or parentage of the child is not known, then the guardian of the child with prior permission of the court. And the fifth one, the court shall be satisfied on the welfare of the child and wishes of the child with regards to age and understanding, and regarding the very explanation as to father and mother means the natural father and natural mother, not adoptive father or adoptive mother. And regarding guardian means testamentary or guardian appointed by the court. And here court means the city civil court or a district court where ordinarily the child resides, and in case of a decree of divorce or nullity between the husband and wife, the consent would be essential for giving adoption of any child out of that marriage. So, adopted child cannot further be given in adoption. And now we'll discuss regarding Section 10 and which provides who may be adopted. So, regarding that, the child must be a Hindu and the child has not been already adopted and has not been married unless a custom or usage permits such an adoption, and lastly has not completed the age of 15 years unless a custom or usages permit such an adoption. And regarding the very explanation relating that the child has not been married unless a custom or usage permits such an adoption, we would like to discuss a important leading case, and that is Maya Ram versus Jay Narayan in 1989. The Punjab and Haryana High Court held that married persons with issues could be taken in adoption, and as there was no provision with respect to age limit in Punjab, this custom also exists amongst the Agarwal and Jain Vaishyas. And now we'll discuss another leading case relating to Section 10 Birana Maheshwari versus Girish Chandra in 1986. The Allahabad High Court held that adoption of a child above 15 years of age in absence of any true custom to be invalid, and regarding an orphan child also be taken into adoption, and the guardian has to obtain the very permission of the court. So also an only son could also be given in adoption. A child of unsound mind could also be taken in adoption, as it was decided in Devagunda Patil versus Sam Gowda Patil in 1992 by the Bombay High Court. So, regarding Section 11, which provides certain conditions for a valid adoptions, and as per the provisions of Section 11, in every adoption the following conditions must be complied with, and such conditions are: if the adoption is of a son, the adoptive father or mother by whom the adoption is made must not have a Hindu son or son or son's son living at the time of adoption. And second condition, if the adoption is of a daughter, the adoptive father or mother by whom the adoption is made must not have a Hindu daughter or son's daughter living at the time of adoption. And the third condition, if the adoption is by a male and the person to be adopted is a female, the adoptive father is at least 21 years older than the person to be adopted. And the fourth condition, if the adoption is by a female and the person to be adopted is a male, the adoptive mother is at least 21 years older than the person to be adopted. And the fifth conditions required the same child may not be adopted simultaneously by two or more persons. And the sixth condition, the child to be adopted must be actually given and taken in adoption by parents or guardians or under their authority with intent to transfer the child from the family of its birth to the family of its adoption, and performance of that homa shall not be essential to the validity of an adoption. And in that connection, as per the provisions of Section 11, we would like to discuss certain leading cases, and one is Alak Chandra versus Pratibhas in 1979. The Odisha High Court expressed that conditions are mandatory for a valid adoption. And in Kasinath Rai versus Mahadev Rai in 1977, the Patna High Court held that actual giving and taking of the child is most essential, not a merely by writing a deed. And in the leading case, Lakshman Singh Kothari versus Srimati Rup Kumar in 1961, the Supreme Court held that corporal giving and receiving in adoption is the part of the ceremony of giving and taking, and in the leading case, Srimati Janki Devi versus Phani Nara Nandan Tiwari in 1988, the Patna High Court held that the ceremony of Datta Homa performed in the act of adoption was not regarded as valid, and in the leading case Ram Jagat versus Srimati Kanchan Devi in 1988, the Allahabad High Court held that where the adoption is oral, all the conditions and laid down in section 11 must be fulfilled where the adoption is in writing and registered. It would be presumed as adoption in accordance with section 11, but only when the signature of the natural father and the adopting father duly existed on the written document. And in the last leading case relating to section 11, Devagunda Patil versus Shyamgowda Patil in 1992, the Bombay High Court held that the doctrine of delegation in the act of adoption is permitted where the parents of either side have grown very old or suffering from serious diseases or have become disabled to perform the physical act of giving and taking to a third party. So, these are the important leading cases relating to section 11, which provide those above conditions. Just now we have finished regarding a valid adoption.